Hi, Max here with FrizWoods, and today we're going to be discussing a question that I get a lot during initial consultations. Can I get my case dismissed if the police did not read me my rights? Well, if you're just interested in the short answer, the answer is probably no, but if you want to know why, stick around and I'll explain. What are your rights, and why do people commonly think they need to be read to you at the time of your arrest? And for this, I blame Law and Order and movies and TV. The reason is that most motion picture films always have the good guy or bad guy getting arrested and some officer of the law saying, you have the right to remain silent, everything you say can and will be used against you, you have the right to an attorney, if you cannot afford one will be appointed to you, and it makes for a really great dramatic scene. What are those warnings that they're reading the defendant or the victim or the bad guy or the good guy? Those are called Miranda warnings, and they come from a United States Supreme Court, which is Miranda versus Arizona. You see, if the state, in this case, the state of Maryland, or the state where you reside when you're watching this video, wants to use a statement against you that was obtained while you were in custody and during the course of a custodial interrogation, then you need to be informed of your Miranda warnings. You do not, however, need to receive your Miranda warnings at the time of your arrest, and in some cases, you do not need to be Mirandized at all. Let's run a few hypotheticals by you. Barry gets into a bar fight. Officer Steve sees Barry hit John in the face. Officer Steve walks over to Barry, takes out his handcuffs, and says, I am placing you under arrest, Barry. I, Officer Steve, observed you hitting this gentleman in the face. Barry goes to trial. And Barry tries to argue he didn't read me my rights, the case should be thrown out. The court disagrees with him because there were no statements that the state attempted to introduce that were illegally taken. As a matter of fact, in a case like that, a statement probably isn't an element or a requirement at all. Here in Maryland, an assault might only require that an officer observe an unconsented to touching or a battery. Let's modify the hypothetical a little bit. Barry is observed hitting a man by Officer Steve. Officer Steve walks over to Barry and puts on those handcuffs and immediately turns to him, holds him by the shoulders, and says, why did you do that? Why did you hit him? Barry, being scared, answers, I'm sorry, I did it because he called my girlfriend a curse word. Now Barry goes to trial, and the state puts on the officer who says, well, he confessed to me. He told me he hit him because he called his girlfriend a curse word. That statement may have been taken in violation of Barry's rights, and it may very well get suppressed or kept out by a judge. However, it may not result in the case being dismissed, because in that particular hypothetical, his statement may be immaterial. It really depends. Let's run a third hypothetical by you. Officer Steve observes Barry hitting a man in the face outside of the bar, approaches Barry, puts his handcuffs on, and transports him to a police station. Barry's put in front of a recording device, and before he's asked any questions by a detective or an officer, he's read his Miranda rights, and they're given to him on a form as well, and he sits there and initials each one as he goes through, and he then makes what the state would say is a knowing waiver of his Miranda rights and gives a confession. Is that admissible in court? More likely, yes. It still may be subject to challenge from Barry's attorney, but that's a situation where Miranda rights are required. Now, how do you get your case thrown out if the police didn't read your rights? And that may be a case where the only evidence, or the best evidence, was your confession or statement that was illegally obtained during custodial interrogation when you weren't Mirandized. In that particular case, if the police did not read you your rights and obtained an illegal confession while you were in custody, then perhaps your case may be thrown out for failure to be advised of your Miranda rights. But every single time a person is arrested, their rights do not need to be read to them. And there are many types of cases where officers and police officers and detectives are not interested in a statement of the defendant and don't intend to use one to prove beyond a reasonable doubt whatever crime it is they say occurred. In those cases, not being read your rights will not get your case dismissed. This is a very case-specific issue, so if you have a case in Maryland, why don't you give us a call and we can talk a little bit more about how a failure to advise you of your Miranda rights might affect your case. Until I see you next time, thank you.